हम लोग बात करेंगे नारकोटिक्स एक्ट का। तो इसका फुल फॉर्म है नारकोटिक्स ड्रग्स साइकोट्रोपिक सब्सटेंसेस एक्ट. So mostly you will be familiar with the drugs, narcotic drugs. What are the scheduled drugs which are prohibited in India? So what are the implication of having in possession of that drugs? Also some of the things which are produced, can you be in their possession? Can you grow it in your house or for commercial purpose? If you do, what are the consequences? What are the things that you may have to prove if you are caught with some of the scheduled drugs? These are the things which has been mentioned in the NDPS Act. So we'll continue with the NDPS Act. The first and foremost thing is, what is a drug abuse? So now drug abuse, if you all know, is that anything which causes a sense of excitement, a sense of thing which is addictive, and people use it to gain access to a different world. That is the drugs that we call the drugs. And what are the other things which is happening or intervened with the narcotropic substances are the organized crime, because you see the NDPS Act, what is drug peddling, is an offense which is having a big network. If you look into that, the heroine and other things, as you've looked in movies, that it has been coming from the different countries, Afghanistan, Pakistan, Punjab border, rest of India. So that is a form of an organized crime, because many people are involved in this crime, and they have their own understanding of their crime, and they have their own role to play in the whole crime, right from the initiation, right from the growing that particular substance to processing to going the meth labs and going to the people, every person who is the consumer, supplying them. There's a whole lot of a network, so this is a form of an organized crime. Secondly, these drugs has a close association of also the human trafficking. Now human trafficking is a issue which we have seen that it is intermingled with the drug issue, and many a times people who are involved in this human trafficking are also involved in the drugs. And similarly, if you look the money laundering aspects also, because drugs and money go hand by hand, because there are lots of cash which is needed for this human transaction, human trafficking, drug peddling, drugs, and lots of cash are involved. That is also in the form of money laundering. So the inflow of cash in these businesses are very likely, and they are intermingled. And also because of these activities, there is a high chance of the HIV, AIDS, which is also promoted through the money laundering, because mostly the money laundering is done for the prostitution part, and these are the one of the major sources of the HIV AIDS in India. Now India has a long standing history of the cannabis and the opium, which is used as a part of social, spiritual and medicinal context. Medicinal and is fine, but when we see the social and spiritual thing, then we see that people are involved in these activities from a long period of time, and they have been doing it on the pretext that it is a spiritual thing to do, or we do it as a prasad. So now that is also one of the things which has to be controlled through the NDPS Act. Second, what we have seen, the NCRB data suggest that drugs and narcotics worth 19.51 crore and 17.5 crore were seized in 2010 and 2009, and now that particular data has just doubled or more than doubled in the recent years. So and they have also said that some of the states like the Manipur or the Punjab, which share international borders with different countries, are there are roughly 18,000 and 25,000 intravenous drug users. That these are the things, some of the things which are directly used through needles, and they are putting it into the bloodstream, and many people fall prey to these drugs One of the major reasons why Punjab is most affected because of the lots of money which it has from the rich farmers and also the Canadian connection which they have, and because of the unlimited amount of money flows which it has, most of the youths are involved in these drug scenes. Drug and psychotropic substance was first enacted in the year 1985, and these deals with the trafficking of prohibited substances, cultivation, manufacture, distribution, sale, and their consumption. So now everything is incorporated into this act, right from the cultivation, the manufacture, the distribution of the same, and also the consumption, and how much it can be used for the medicinal purpose, what is the quantity which can be used for the private purpose. So these have been defined under the NDPS Act. Now, NDPS Act, it has been said that these cases are dealt with the sessions court only, though it has been suggested that the specialized courts need to be made for handling the NDPS acts. But till now, we don't have specialized courts, though 1989, this act of 1989 under section 36 empowers the government to set up the special facilities, the special courts for expeditious disposal of matters. And as we have seen in Article 14, even if that special court has been established for dealing with these cases, so it will not be violation of the Article 14 of the Constitution. But what we see till date, that they have not come up with the special codes for dealing with the NDPS Act. Maybe in the near future we will see that the special courts have been formed for dealing with the NDPS Act. Now, some of the things which has been mentioned is the quantum of punishment under NDPS Act is based on the quantity of drugs found, that may be classified into three categories. That is small, less than commercial, and commercial. So these are three categories for the offenses. As a result, the punishment may be as low as the rigorous imprisonment for 1 year if the drugs are found in small quantity, and as high as 20 years if the imprisonment is for large quantity of drugs. So now, in a NDPS case, the foremost important thing which we have to see is the quantity of the drug. Also, we have to see that what is the nature of the drug, what is the it's a synthetic drug, it's a natural drug, it's a natural form of a psychotropic substance, or it is a clinically made, that is there. But when we talk about the punishment aspect, we have to see in what is the quantity that it is in possession of that person. So the punishment can be anything for a period of 1 year to the maximum punishment of say 20 years. So now there are some of the drugs which has been mentioned here. So cocaine, for let's example, small quantity 2 gram, commercial quantity is 100 gram. Now if there is a 100 grams of cocaine, you are in possession of say more than 2 grams, so it will be an offense that is for the commercial purpose. So now you will be punished accordingly. So now ganja, that is a small quantity, is 1 kg. So if you are caught with less than 1 kg, you may not be punished for a harsher punishment, but when you, if you have a 20 kgs, you will be accordingly punished. So poppy straw is again 1 kg. So some of the things which we see is because of the quantity. So now when we see the quantity, the important part is that you have to weigh those things, that particular person was in possession of the certain drug, and certain drugs was in this quantity. So there are two things which has to be seen accordingly, that first it was a drug, and second it was the drug which was in that specific quantity. So first and foremost thing which the forensic people you have to check is that if they say that you are caught with say 2 grams of cocaine, so first you have to prove that the material which has been taken over by the possession or in the possession of the police, or they have been taken out of the possession of that person, is cocaine. So if that person is in possession of cocaine, that person will be punished. And second, what is the commercial quantity, what is the quantity which they have taken up. So now there is a whole lot of thing which is in the domain of the police person and also the forensic scientist, because there are many cases which we have seen that the police have actually managed to bring the weight less, bring the quantity, or they usually take up that quantity, destroy the quantity, and weigh the drugs in such a manner that it does not fall under the commercial quantity. Also, we have seen when it is going for the forensic laboratory for checking whether this is a cocaine or not. So when we see there are that is a disprin, or that is a glucose, and they have changed it, or there are the reports are not positive. So now there are certain things which has been given for the prosecution agencies to check whether they are in both the possession and also the check of the quantity. Section 8 explicitly prohibits the cultivation of opium, poppy, coca, or cannabis plant, as well as the production, manufacture, distribution, including warehouse, transport, purchasing, and selling of prohibited drugs and psychotropic substances. We have seen that the opium is used mainly for the medicinal purpose, and that is why we give the rights to cultivate, manufacture, distribute these drugs. Now if the schedule does not say that you can use it for medicinal purpose, and they use it for medicinal purpose, so suppose a person has been granted a license to cultivate opium in 1 acre of land, then he has to do it within 1 acres. And also when the plants are ready, the it will be taken, or it will be seized, or it will be taken in police custody. When the plants are ready, it has to be taken out of the farm, and that should be in the police custody, or that the police protection. The police will protect the area, and they will make sure that the 1 acre, whatever the cultivation is there, the cultivation is taken care of and is given to the particular manufacturers for their drug limit, and it will be supplied to the respective companies for their manufacture of the scheduled drugs. Section 19 says any farmer who cultivates opium in accordance with the license put embezzles it is punished with rigorous imprisonment for a term ranging between 10 to 20 years, and also be liable to pay a fine in a range of rupees 1 to 2 lakh. So now a farmer who has cultivated opium in accordance with the license, but he has made use of the 1 acre of land, he has done it for 1.1 acre, and he has submitted the opium which is in the 1 acre, and has managed to not give the zero point 0.1 of the cultivation. So now if he is charged with that particular offense, he will be punished for a term which may range from 10 to 20 years, and also will be liable to a fine of 1 to 2 lakh rupees. 23 says any person who is engaged in the illegal import, export, transshipment of narcotic drugs, psychotropic substance shall have to face imprisonment ranging between rigorous imprisonment for 1 to 20 years, and also a fine ranging between 10,000 to 2 lakh based on the quantity of the prohibited substance. It is now illegal import and export of narcotic substance. So now many countries have different rules of dealing with that. So if you are going out from India and taking a scheduled drug, you will be punished, and you are actually caught in that particular country, they will deal with you as an offender, and their punishment or their act will be applicable even. And similarly, if someone is coming from abroad and he is bringing some scheduled drugs with him, with her, then he or she will be punished according to the NDPS Act, depending upon the quantity and also the nature of the psychotropic substance. 24 clearly states that a person who engages in external dealings in contravention of drug shall be punished with rigorous imprisonment. So now there is something which is for the drug peddlers. They are not the manufacturers, they are not the producers of the drugs, but they are the agents who are selling the scheduled drugs. For that, there is a different section which enumerates the punishment for those offences, which is 10 to 20 years, and also a fine of rupees 1 to 2 lakh rupees. Thirdly, any person knowingly allows his premises to be act in the further commission. These are the intricacies of this act which we are seeing, because there are some of the things which the people can say and want to get away with the crime. So if for that purpose they have said, for everything, like you have given a house to a person who is a drug addict or he is involved in drug peddling, and you have the news and you still does not do not say them to vacate the house, or what you do is like you make a arrangement with them and say that okay, I am also a party to it, and you carry on your business. And after that, what you get is that police comes to your house and they say that your area was used as a drug peddling platform, and you say that I was not sure that people are using this thing for drugs abuse, or they are drug peddling, so please don't arrest me. So exactly this section talks about it. And anyone who knowingly allows his premises, now if he is involved in that and knowingly allows his premises, he will also be punished for that offense. If he is not knowingly done it, or he has no knowledge about it that his premises is being used, then that person will not be punished, though he has to prove that he has no knowledge about that particular thing, that his dwelling house or the area which he has given on rent was being used or as a drug peddling platform. Now, this procedural safeguards is also been said that extensive powers to law enforcement agency to clamp down the MAC practices. So now there are some of the things which we see, that there is a whole lot of power which has been given to the inspectors who are involved in the controlling the narcotics and psychotropic substances. So what they have said, that any person making an arrest or seizure, and that there is required to make an extensive report containing all relevant detail must be sent to the immediate superior. Like section 100 of CRPC state, any police officer who wishes to search any person who is believed to be concealing something suspicious must do so only in presence of two respectable inhabitants to the locality called the punches, and or therefore the statement containing detail of the search and seizure with the signature of must be given to the accused of his perusal. Now when we have talked about the person, when the person has to be arrested, there has to be supported by two independent witnesses which are called the punchers. Now it is done when you are in a position or in a place where you find people. If the person is arrested from the jungle, from a secluded place, from a place where there is very less traffic, then you cannot find the punchers. Then there are some of the things which raises question: what was the quantity, what was the substance which was being used, was it planted on the person who was going in this direction, or the police planted it, or whatever that question comes is in the absence of these punchers, raises a different issue before the court altogether. Now this is a very particular thing about section 55 of obligation on the police officer seizing the prohibited to keep them in safe custody. They must contain the seal of the officer seizing them as well as the officer in charge of the police station. So it gives a duty on the police officer to keep the substance safe, in safe custody, and also sign on the exhibits, and also the officer in charge of the police station. So now though we have seen that it is the duty of the police officer, but there has not been prescribed time limit under what time the police officer should send it for the forensic report, forensic investigation. And in absence of these time limit, there are chances that the chain of custody may be compromised. Section 50 also Act gives the right to be searched in presence of a magistrate of the gazetted officer. So now if there is an accused and there is a prior information, then the magistrate and other person can be called upon to be present in the search. But that is not the case, or that is not practically feasible to conduct it every time in the presence of a magistrate. Now, the case which has been mentioned here is the state of Punjab versus Balbir Singh, where it was held that the police must, of necessity, inform the accused about this right Finally, Section 55 impose strict punishment of people making vexatious or frivolous complaints. So now, because this is an extremely important right which has been provided, the magistrate and other person cannot be present in the every search and seizure. So the panchas has been identified, and it has been confirmed in the state of Punjab versus Balbir Singh that the accused has right that the panchas be present, and also the person who has given a wrong information shall also be punished for the giving the false information. So now there is also a agency, central agency, which is called the Narcotics Control Bureau, is also responsible for taking undertaking the various law enforcement agencies and also the compliance with the various international instrument that India has signed. That there is an independent agency apart from the police. They are also involved for controlling the narcotics and psychotropic substances, prohibited substances under the government of India. So apart from that, police is they are also involved. Generally, we have that particular narcotics control bureau, which has its offices in most of the places, particularly in the cities where the crime rates are the controlling the psychotropic substances is necessary, and also the manufacturing, selling, prohibiting these things are an absolute necessity. They are also functional in some of the state borders where the drugs come from different international borders. Now, these are major shortcomings if we talk about the NDPS Act, is that Section 35. Now, this is very important because what you have heard about the burden of proof, because burden of proof is always on the prosecution, that the prosecution has to prove the guilt of the accused. Like, the prosecution has to prove beyond reasonable doubt that the accused has committed the crime. It is true for all the offenses under IPCs, but this exception is one exception is there in case of IPC, in cases of rape, where the prosecution does not have to prove that the accused has committed the rape, but the person who is accused of the crime has to prove that the act which he has committed was a consensual act. That is one of the exceptions under IPC. And also, under the NDPS Act, it has been mentioned that the onus of proof is on the accused that he has not committed the crime, and not on the prosecution that they have to prove beyond reasonable doubt that he was involved in the drug manufacture or peddling, or he was in possession. It is not the duty of the prosecution to prove so, but it is the duty of the accused to prove that he is innocent. So it has been said that Section 35 presupposes the guilt of the accused. Now, presupposes the guilt of the accused that he is the person who is involved in or he has done the crime, and puts the onus of the on the accused to prove that he or she is innocent. That is against one of our fundamental principles. Until and unless that person is proved to be guilty, he is presumed to be innocent. It is the other way now. He is presumed to be guilty, and he has to prove his innocence. So now that is against the whole fundamental principle of the criminal law, which we have mentioned under the NDPS Act. It further states, unless the contrary is proved, it will be believed that the accused intentionally held the illicit drugs that were found in his possession. There is a sharp contrast with the notion that accused is innocent until proven guilty, which is pillar upon which the edifice of most statues in India's rests. So now, this particular act has been criticized, though it has not been removed, because it is against one of the fundamental principles of the criminal law. Secondly, it is widely believed that the act does not make adequate distinction between a casual drug user, a hard addict, a petty peddler, and a seasoned drug trafficker. Now, that is again one of the shortcomings of this act, because a person who is usually taking drugs, but he's for his own consumption. Secondly, a hard addict who cannot survive without that particular drug. Third, a petty peddler who is buying for himself and his friend, and a drug peddler who is doing it for the say a particularly city. So now these are the different types of person involved in different types of organized crime. Though a person who is buying for himself is not doing any organized crime, but in the similar manner, a drug trafficker who is getting the drugs for the whole of the city, he is an organized criminal. But they do not, the NDPS Act has not clarified the difference between the hard addict, a petty peddler, a drug trafficker, a drug kingpin. They have made them on the similar platform. They are all treated equally, and they have taken this article 14 too seriously. So there should be distinguished among the person who are doing the crime. So there will be different notions who are involved in this particular crime, and they will be different involvement of these person in these crime. Furthermore, it also does not make any meaningful distinction between hard and soft drug, which is reason why many drug users resort to hard drugs, because in most cases punishment that their use encompasses does not significantly differ from the punishment that is handed down from those who use soft drugs. So now there are classification on the basis of hard drugs and the soft drugs, but the punishment prescribed for the hard drugs and the soft drugs is not because of the nature of the drugs, but nature of the possession and nature of the quantity. So people get involved in the hard drugs only because even if they are using the soft drug, the punishment if they are caught will be the same. So it promotes a thing which is not in favor of our country, that it is people get involved mostly for the use of hard drugs, and that is major shortcomings of this act. So hopefully this NDPS Act, you have to remember, is the burden of proof that is the main highlight of the NDPS Act. That in NDPS Act, the accused is presumed to be guilty and he has to prove his innocence. On the other hand, the general criminal law presupposes the person to be innocent until proven guilty. So that is the major difference in case of the NDPS Act. Thank you.